with respect to these meetings with the 1600 group, what happened?
I I did start to make improvements in the area, and I don't know that it's noted anywhere, but then there was that allegation that came later on that stated that I wasn't running groups, and that was a later, there's statements from particular individuals who stated that I didn't run group, but there are also statements in here confirming that I did. There were CNAs whose names were blanked out, but I know there's the first initial M and the first initial R who did vouch for me. There is.
Well, let me ask you this. I mean, did you maintain any type of log of, for instance, how many times that you did the 1600 group, what dates, times, that sort of thing?
I charted every day. If I did not personally run the group, I still charted, and it charted on what the CNA ran. I got the attendance list of the patients who attended group, and I did chart on the nature of the group and the attendance of each patient.
No, I mean like a personal log for yourself, for your own purposes.
I don't know. That wasn't part of the responsibility for running 1600 groups. There was a daily log, but it wasn't something that was kept permanently.
I mean, in the sense that you're being accused of not running the group on a regular basis, I would think that starting after June 19th, 2020, you would want to make sure that you documented every day that you ran the group, so that if there was any question later on, you could go back and say, well, here's all the days that I ran the 1600 group.
And that was it reflected in the charting in the electronic medical record. And Mandy audited the groups once a week to make sure that they were being done and charted correctly.
But when it came to the discharge on September 4th, that was one of the reasons, if not the primary reason for the discharge, at least according to Brown County, was that you weren't doing the 1600 groups, correct?
I was doing them or delegating them, but that was the allegation, correct?
All right, but at that point in time, you didn't have, for instance, a document that you could provide to Brown County that said, well, here is all the times that I did the 1600 group. What's wrong with this performance?
I didn't print out the patient, each log with the patient information. There wasn't in particular a log that could have been printed out. I could have kept one myself, you're right. But I didn't print anything out because I was concerned about HIPAA as well, including patient names. But I did, you're right, I could have kept a personal log.
Because it seems like that was the primary reason why the Brown County people were upset with you, at least according to what you'd said in your testimony, that the 1600 group was a problem.
It was it was one thing in a jumble of different things that were going on, but it was one thing that was going on, and we actually discussed it, and I had to have a meeting with Mandy for my PIP every so often, and we would discuss it at that time too.
Okay, and so let's talk about that then. So the performance improvement plan dated June 19th, 2020, is designated as a 90-day performance improvement plan. And so how often after June 19th, 2020, did you meet with Mandy to discuss your progress?
It was bi-weekly meetings between Mandy and myself, and that's on the PIP. It's page BC 109.
Okay, and so bi-weekly meaning like every other week, is that it?
Correct.
Okay, all right. And what was discussed with Mandy at these bi-weekly meetings?
And she stated, you will be required to bring any questions or concerns for discussion, give project updates, and address current staff challenges. So it was anything that was coming up, anything that was a challenge, or if I had questions about an audit or anything that had to be done, or if she had feedback about my performance, that's what we discussed during those meetings.
Okay. So I'm guessing that you had at least 4 meetings then over July and August of 2020 to discuss the performance improvement plan. Is that right?
I believe so. I don't have I did not write down the dates that we met, but I believe it would have come out to 4. I did speak with Sam on one of those occasions as well. She was in one of the meetings.
All right. And what was the general tone of Mandy and I guess Sam on that one occasion when you met with them on these performance improvement plan meetings?
Um, in the beginning, the tone was a little less, well, it was a little less confrontational, or I don't know I don't know what word to use. It felt like a little less accusatory in the beginning, and then it kind of amped up from there. Some of the meetings were a little bit, um, uh, for lack of a better word, a little nitpicky. There were littler things that hadn't hadn't ever been an issue before that started to come up.
And do you remember any of those conversations where, as you describe it, the conversation was somewhat amped up by Brown County and you felt that they were nitpicky about things?
Yes, when she brought Sam into the meeting and was discussing an instance of inappropriate communication, I actually brought the matter forward, but it was something that they had intended to address with me anyway. Um, they stated I was less willing to help with the floor responsibilities or doing both roles as charge nurse and floor nurse. Um, but I don't have, it was more of a general tone.
Okay. And so did you uh, did you understand from these meetings that Brown County was dissatisfied with your performance?
That is exactly what it seemed like. Yes. However, in my review and my evaluation from just several months prior to that, and I did submit that, it's completely contradictory. It was a favorable evaluation, and she made several comments about things like my communication skills that I had excellent communication skills and that I effectively multitasked. So it was contradictory to what I'd heard just a month or two before that.
All right. Well, you have alleged that Brown County discharged you because you opposed discriminatory practice under the Wisconsin Fair Employment Act. And what evidence do you have that that was the basis for your discharge?
So back on May 18th, I think is when it started. It's the text that I submitted, and there are 7 pages, and it started with Mandy asking. She's on the left side, I'm on the right for the texting purposes. She said, "Would you feel better about going back to PM shift hypothetically?" That was page 1.
Okay,
Um,
well, I guess, and I know that's I'm just looking at Exhibit 26 for the respondent. Are those the text messages that you're referring to?
No, these are texts that I submitted in my paperwork.
Okay. All right, I will find those 7 pages of text messages with Mandy.
Okay.
Go ahead.
And she stated, I understand it all, but I can't explain to other people. They don't understand how you get away with it, in quotations, but I can't explain it to them. And what she was talking about was to other employees who were complaining about my not being there, but they were FMLA. It was FMLA intermittent leave. And then on page 7 of the text, Mandy states, I understand. I'm just getting so much flack from everyone, and I can keep 0 people happy. That was one instance of the communication. On June 1st, there was an email when I asked, she actually stated, as you know, your frequent absences are also noted by other staff members.
Judge, I just, point of clarification, I don't know what she's reading from. Nothing's been identified.
Miss Devlin, what are you referring to?
The text messages initially, or are you talking about the next statement when she states, as you know, your frequent.
Yeah, you identified it as an email, and I think that's what Attorney Nelson is saying. What are you referring to? Is this a document or an exhibit that's been?
Yes, and then another email that I did submit is I'm sorry. BC 102 and 103. On page BC 102 of Exhibit 9.
You're talking about the respondent's Exhibit 9 now at this point.
The
Is that right?
respondent's exhibits, yes.
That's previously been marked as Exhibit 4 for today's hearing. Go ahead.
She stated that so then what she stated in this email from 6/1, as she states, as you know, your frequent absences are also noted by other staff members. And that was in an email to me.
Which page again were you on?
BC 102.
And for context, if she's going to read that sentence, she should read the entire paragraph.
Okay.
Okay. Well, yeah, as the completeness doctrine calls for. Go ahead, read that, Ms. Devlin.
Okay. Unfortunately, she states, Rachel, unfortunately, this is not protected by FMLA, so you need to follow the attendance policy. That was in regards to the dentist appointment. She states, as you know, your frequent absences are also noted by other staff members. Bringing another staff member's names into this discussion is not appropriate, as, like your situation, you are not privy to another employee's personal situations. Following policies and procedures is not nonsense, and I would appreciate more professional correspondence going forward.
Thank you.
Okay. And so there was a discussion of this requested early departure from work to attend a dentist appointment, correct? And this individual, Mandy Woodward, is saying, well, that's not covered on your FMLA, so you'll have to, fall back on the regular procedures for asking for time off. Was she wrong about that?
About following the policy for that time off?
Yes.
Yes, she was for that in that instance. When she said, though, as you know, your frequent absences are also noted by other staff members, I wasn't certain that she was, it sounded like she was, in my opinion, it felt like she was alluding to all absences. And I responded by saying, if you make the point, and this is on the same page just above that, it's on VC 102. I said, if you make the point that I'm not privy to other employee situations, with which I agree, then it's also inappropriate to say anything about my frequent absences, which are mostly FMLA, and LC means low census. So they can't even legally be spoken to. Going forward, what I would appreciate is improved communication and a lack of bias, in addition to reciprocated professionalism. Thank you.
Okay. All right. And then apparently then Ms. Woodward responded to you saying that frequent absences refer to non-FMLA or low census. Is that right?
Correct. She did respond with that. Yes.
But getting back to the dentist appointment, it was not covered under FMLA. Would that be a fair statement?
Yes, correct.
And so not being covered under FMLA, then you would have to follow the regular attendance policy for the employer?
Correct. And that's why I had canceled the request.
All right. And so getting back to the original question. So we've talked about the nature of the discharge. We talked about the performance improvement plan and some of the incidences that were discussed in that. We've talked about some of the meetings that you had with supervisory staff in the course of the performance improvement plan. And then we've come back to the allocation that you made, that you were discharged because you opposed a discriminatory practice under the Act. And so what other evidence do you have that you were discharged because you opposed a discriminatory practice under the Act?
In Exhibit R5 from the respondent, it's page BC 088.
All right, let me get there.
Sure.
All right, this will be marked as Exhibit 6 for today's hearing. And what is this document, Ms. Devlin?
What it appears to be, and I hadn't seen this prior to this, it was a request from, it's from Luke Newton, but I think it was in the two field, it was to Mandy and to Tammy, and it was stating, it was actually asking about my intermittent hours to verify the validity of the FMLA. It was requested on August 25th, which was 10 days prior to my termination. And if groups had been the issue and my attendance hadn't been the issue, I wasn't sure why he or they were trying to discredit the protected leave.
Object to the form of the question, or I'm sorry, not the form of the question. I'm going to object to the testimony is lacking foundation and based on speculation.
Well, I think that it probably does broach on that, but I'm going to let the witness testify about it. Go ahead, Ms. Devlin, you may continue.
Okay. So what I didn't understand was if there was a case about the groups, why my attendance and this was actually on a day that I had taken an FMLA day as well. So it was August 25th, and that's on the Unum calendar for August that I submitted. It shows that I did have an approved, well, I did take an FMLA that day, and that was a day that they asked and investigated, and I guess anything that I say is speculation because I'm not sure why they were looking into this, but I didn't feel that it was relevant to the points that they had been trying to make. And if my attendance wasn't the issue, or if my FMLA days weren't an issue, why were they looking into them? Was my
What
question.
what day did you miss?
It was August 24th and August 25th, counted as one encounter. It was just 2 consecutive days. So it was August 24th and 25th.
Okay. And so you missed those days for what reason?
It was related to the intermittent FMLA leave. I don't remember exactly what had been going on. I know that I was feeling a lot of pressure on the job at the time, and I was feeling very overwhelmed. I know that.
All right. Any other evidence that you want to submit as it relates to the allegation that Brown County discharged you because you opposed a discriminatory practice under the Wisconsin Fair Employment Act?
Let's see. My apologies. I'm just reviewing my notes. My attendance record under Exhibit R18, the respondent's Exhibit R18, shows that I was at level 2 for my attendance, which means verbal warning for absences prior to my performance evaluation on April 23rd of 2020. So I was at level 2 at that point, and I was talked to about it, and so that was that was the second level of discipline. But then we talked about the absences then during my performance evaluation, and she did state that that was an area that needed improvement. From that point, I did have and then there was one instance, there was a tardy after that on page BC 120. After the evaluation, there was one tardy and one instance where I was late, but I had really tried to improve from that point, and it still seemed to come up. Mandy still continued to bring up my attendance after that.
Okay, just for the record, then I've marked respondents 18 as Exhibit 7 for today's hearing.
And I did talk to Samantha Bailing, in early June. It was actually in person, because at that point in time, before I had even received my PIP, I did talk to her about feeling like I had been targeted in regards to my attendance, and about there were multiple things that had been going on in the unit. She sent an email on, and this is something I submitted. She submitted an email on Monday, 6/22 of 2020, stating that she documented our conversation, and she stated that she kind of recapped our conversation, and I had come to her with my concerns, and the only follow-up that I got was this email that recapped our conversation.
Well, when you talked to Ms. Bailing in early June 2020, what specifically did you talk about as it related to your idea that you were being targeted?
She states, is it okay if I read the email?
Go ahead.
Okay. She said, "Hi, Rachel. I documented our conversation on June 9th as June 19th, as well as informed human resources of the supervisor-employee dynamic. I've included your shared concerns relating to comments shared from other employees that you would get in trouble but have done everything legally when referencing an alleged DON conversation with your peers. I'd included the concern about the comment asking if you'd rather go back to PM shift, hypothetically. That refers back to the text on May 18th from Mandy. And general feelings that your actions are being targeted relating to use of FMLA days, as well as a dissolved friendship with a DON. You'd shared with me concern about your employment and attested to the productivity and outstanding performance outside of the group therapy matter, stating that you wish to remain employed and enjoy your role in our facility. Another example of feeling targeted related to the low census rotation. You'd been excluded from the rotation, which seemed punitive. On a day in which you were permitted to leave early, the DON called you to return to work to take care of your responsibilities, which you felt were not urgent and a bit of a stretch for being time sensitive. You shared perception of unprofessional or overly direct tone within the context of emails. But in here, that I already covered the part where I asked about where I had talked to her about FMLA, and she did recap that in the email.
Okay. All right.
There was never any follow-up from Sam.
I'm going to mark that document as Exhibit 8 for today's hearing. Any other evidence that you believe supports your allegation that you're discharged because you opposed a discriminatory practice under the Wisconsin Fair Employment Act?
No, it just felt like it was there's nothing else that I have that's concrete, but it felt a little more insidious than that, and there were comments made in person as well, but I don't remember exactly what they were. But that's all I have in terms of the evidence presented today.
All right. The other allegation that we're here to talk about today is discriminating against you in the terms and conditions of employment because of disability. What is it that you're contending was your disability?
The disability is bipolar disorder, and Mandy was aware of that, and there were times when she asked if I had been struggling with the workload, despite the fact that I was working as charge nurse and floor nurse, dual roles. And then she was adding additional tasks. She added the first admission of each shift to my workload, and then asked if I was struggling with this, if I needed additional assistance. And I'm trying to find let's see if I can find that email. And then she asked, would you, in the texts from May 18th, she asked, would you prefer if I put you back onto PM shift? And just stating that she stated that the shift needs a consistent charge nurse and that my FMLA absences were interfering with that. So she was.
Well, what exactly is she referring to? I would object to her testifying to what Ms. Woodward is alleged to have said without identifying the document.
I will find that. It's in an email. One moment. I'm sorry.
Is this an email that you submitted, Ms. Devlin, or was part of the?
I think it was in both. It was actually in both. So I can refer to it in the exhibits. Struggling. There's an email where she states I was struggling, and I have an index here I'm trying to find here. Statement email to explain groups to stay on another email about groups. R22. I thought I had made a note about that, and it was in an email exchange with Mandy. I'm trying to find that. I am so sorry. Okay. I will. I will have to skip that because I can't find the email, and I apologize.
Okay. All right. Is there anything else that you wanted to offer in terms of evidence regarding your allegation that Brown County discriminated against you in the terms and conditions of employment because of disability?
And I do not, because I can't find that other email, so I don't have the other email to present where she asks she had been asking if I was struggling with the work assignment. If I find it, is it okay to come back to it?
Yeah, and you know what? Why don't we do this? So you indicated you don't have any additional evidence or testimony to present at this time. Let's take a little break and come back in about 10 minutes, and then Attorney Nelson, if you have questions for the complainant, you'll be able to ask those at that time.
Okay, that sounds great.
All right. So let's
So,
come back. I've got 10:36, 10:46.
Okay.
10:46, got it. Okay.
All right.
So I'm just gonna turn off my video and mute. Is that okay, Judge?
Absolutely. I think everyone should do that. Yeah. And I'm gonna stop the recording, or pause it, I should say. Recording yet.
Oh,
So let me go. We're back on the record in